Okay, so first things first, the Immigration Act 2016. This is an extension of the Immigration Act 2014, as I've already said. And this is just detailing to you what we have to do to comply. So, offences for landlords and agents. So as a landlord, if you rent a property to a disqualified person, somebody that doesn't have the right to reside in the UK, you are committing an offence. Now remember, for those that have heard this before, it's not just the tenants that have to comply with the Immigration Act, it's all occupiers. So anybody that's living within the property has to have their immigration status checked. So if you move in a gentleman and he then moves in his wife, you must check their right to rent residency. We must see evidence of their ID and that they have the right to reside. Not informing the Home Office of a disqualified person, both you as landlords and us as agents will be committing an offence if we don't notify the Home Office of a disqualified person. And for an agent, failing to notify a landlord when we know that we're renting to a disqualified person or an illegal person is something that, if we carried out as a letting agent, would be our offence. We would be the guilty party. So in 2016, they changed the penalty for this, and they actually made it now a criminal offence, so that actually we can now face 5 years imprisonment, which is quite scary really, because how hard is it to control who's living in your property? We all know that people make applications, and we all know that people sometimes tell lies on their applications by way of, oh yes, I'm going to be renting that property on my own. They've not told you about their wife because the wife's got a county court judgment, or she's not working, or they might want to just be getting the single person discount on the council tax. But this does happen quite often, which is why with the Immigration Act, for the landlords out there that manage properties themselves, please make sure that you're regularly inspecting so that you are aware of who is residing in the property. Because I certainly don't want to go to prison for 5 years for this offence, and I'm sure you don't too. The fine now is also unlimited, whereby previously it was £3,000 per illegal occupant, but now that fine is unlimited. So, with the Immigration Act 2016, they had to make some changes to allow us to enforce this. So, eviction of unlawful overstayers. You could have two scenarios. You could have a property where all of the occupiers or all of the tenants are illegal. They don't have the right to reside. But you could also have a tenancy where you've only got one or two occupiers or tenants that don't have the right to reside. In both cases, you are able and you must evict the tenants that do not have the right to reside, or the occupiers that do not have the right to reside. You have to evict them. But how do you do that? So when we've got unlawful occupants where they are all illegally living within the property, what happens is the Home Office will serve a notice to say these tenants are deemed as illegal and they must vacate within 28 days. Now, Sally talked earlier about the Protection from Eviction Act 1977. This is the first time since that date that in the private rented sector we have been able to evict tenants without going to court. For those of you that have experienced ever evicting a tenant, I know you guys have recently and it's been interesting for you, it's quite a lengthy process, and it's not possible without going to court and getting a possession order and then following on with bailiffs and so forth. But for the first time ever, we can now do, for the first time since 1977, we can now do that. So you can imagine the likes of shelter and these people that are all caring for the tenants and not the landlords were quite concerned about this. But it is the only notice that we can serve, and they must leave within 28 days. If the tenancy is a mixed tenancy where you've got some illegal immigrants, but the others are, you know, perfectly reasonable and able to live there and have the right to reside, again, the notice will be served by the Home Office, but what you're not able to do is take back full possession of the property. You have to allow the tenants that have the right to reside to remain in that tenancy and for the tenancy to continue for the fixed term period. So the way of doing that is they've added a new mandatory ground to the Section 8 notice, which is ground 7B. It's a mandatory ground, and I believe it will give the same required 28 days notice to the illegal overstayers to vacate the property. And the ones that are there correctly can continue with the tenancy thereafter. So unfortunately, as landlords, we wouldn't be able to terminate the tenancy. We would only be able to evict the tenants that were staying illegally. So all in all, it hasn't really caused too many challenges, but it is most definitely something to be aware of and interesting over the next few years how this will pan out, and when case law and things like that start to happen, we'll know more. Okay, so interestingly then, the new thing that's on everybody's tongue that nobody seems to know about, council tax. So at the moment, do we know who is liable for the council tax in a rented property? The tenant. Is that in all cases? Not in a HMO. What if a tenancy was 3 months? Would the tenant be responsible for the council tax? Do we all think yes? Because I did. I didn't think that the duration of the tenancy had any bearing on who was responsible for the council tax. But actually, if a tenancy agreement is less than 6 months, the landlord is responsible for the council tax in the eyes of the council tax regulations. So any landlords out there doing 3 months tenancies, 4 months tenancies, landlords could be deemed liable for that council tax. So in this case, what happened, these are the facts about this case that has brought this to the forefront of everybody's minds at the moment. A guy called Mr. Broadley was a buy-to-let landlord in Leeds, and he owned 5 properties which were all let on 6 to 12-month ASTs. So bearing in mind what I've just told you, that a tenant is liable for the council tax if a tenancy is for 6 months minimum. In this case, the tenants should all be responsible for the council tax. What happened was, all of the tenancies became rolling. Do we all know rolling contracts? SPT, yeah? That's what we call it, statutory periodic tenancies. When a fixed term ends and neither party has given notice, the tenancy goes on to a rolling contract. Do we all remember Super Strike v Rodriguez, which was the big case about deposit regulations? Well, in that court case, if you all remember, what they decided was that when a tenancy became rolling, in effect what we were creating was a whole new tenancy. Do you remember that? And that's why we had to register the deposit again, issue the prescribed information again, because those are the requirements when entering a new tenancy. Eventually, they ironed out all of those problems with the Deregulation Act, apart from one, which was the fact that they said every time a contract goes rolling into an SPT contract, it is still deemed a new tenancy. So that still stands. So if a contract goes rolling SPT and it's now month by month, how long is the duration of that contract? 1 month. So therefore, who's liable for the council tax? The landlord. So this is a big problem. This was a big problem, particularly for Mr. Broadley, who owned 5 properties, and Leeds Council was going after all 5 houses, and he wanted the council tax. Now, if you've got a tenant in there and the tenant's paying the council tax, I can guarantee you most certainly they're not going to say to the tenant, just to let you know, we're not going to charge you anymore, we're going to charge your landlord. But in this case, what happened, all of the tenants were on housing benefit. Do housing benefit applicants pay council tax? So are the council getting their council tax out of these 5 properties? Do you think that they thought to themselves, oh, I know what we can do. Well, we're not going to get it out of the tenants. They're now in new tenancies. What we'll do is get it off the landlord because he's rich. He'll pay us, and then we'll be getting our money, because you know the councils are all about income, income, income. So that's exactly what they did. They went after Mr. Broadley for council tax on all 5 of his properties. Now, Mr. Broadley was very clever, and he perhaps should be stood here, because what he had done within his AST, he'd put a provision in there that stated after the expiry of the initial fixed term, so we've got the start date, the expiry date, he had a clause in there that just simply said, and becomes monthly periodic tenancies after the end of the fixed term. So it's quite a simple clause. It's not gone into statutory periodic, it's gone into a monthly rolling contract. But with that clause, what that done was saved him having to pay that council tax. However, it was quite a long journey. It didn't happen straight away. The council sought council tax from him under the 6-month rule for periods when the tenants had left but they had not formally ended the contractual periodic tenancy. But he had to go through the whole of this process to get to the point where they eventually couldn't charge him the council tax. So the facts of the argument were that the council claimed a tenancy couldn't be both fixed and periodic, and the agreement failed for uncertainty. The council also argued that the fixed term, a periodic tenancy, that the new periodic tenancy was again, a new tenancy following the ruling in Superstrike, as we've said. But this gentleman, he took it to the valuation tribunal. It was rejected. It then went to the High Court, which was rejected. The Leeds Council then appealed again. They were taking this all the way, because you imagine how many benefit tenants there are out there that they're not. Pardon? And students where they are not getting council tax paid on their properties, and they're now thinking, this is great, we can get it off the landlords. So they did take it all the way. And the final Court of Appeal, they rejected it, and it was ruled that he wasn't liable for the council tax, but only because of that clause. So what should we learn from today? There's 2 things that we should learn from today, because we certainly learned from this. And immediately we went back to the office and we made amendments to our contract. Sally spoke to you earlier about thinking ahead of these regulation changes, these game changers. We also sat there and we thought, well, we've got tenancies that have been going on for ages. How are we going to get that clause in there now? Because it wasn't in there before. Every tenancy that we do now will be safe because it's a new tenancy and it will be in there. We made the changes about a month ago, 6 weeks ago. So any new tenancies will have it in there. But just think, if you guys let your contracts go rolling, is that the right choice? Bearing this in mind. Should you maybe do a renewal of contract for a further fixed term, get that clause in there, and then next time you'll be safe? Because, okay, so the clause is just that the tenancy becomes monthly periodic tenancies after the end of the fixed term. There's further details than that. It is a little bit more detailed. There's another section that we've put in, which I'm happy to share with you all. You're all landlord clients of ours. It will be in the new contracts anyway. So if any of you want that, just drop me an email and I will send it to you. But it is important that you make sure that this is in there. Otherwise, you could find yourself, particularly if you rent to, as Sally said, students, housing benefit tenants, which I know some of us in here do, that you don't fall foul of this. It's quite interesting because not even the council have heard of this case. I've had several arguments with Wolverhampton Council because they don't know about this case, and when I tell them and when I send them some details, they're like, oh, okay, then we won't chase you. Because other problems that you find is when tenants vacate the properties prior to the end of the fixed term, but claim they're not responsible because they left 3 weeks before. It doesn't matter that my contract didn't end till then. I wasn't living there, I was living somewhere else. Because what they say is tenants can't pay council tax on 2 properties, but why should you as landlords then? I'm presuming you're all paying council tax on the properties you live in. So why should you have to pay more? Sally?
Just want to point out, talking to an agent in Halesowen, that Dudley Council is actively pursuing landlords in Dudley. So if you have any properties in Dudley, jump on this straight away. They're active in Dudley.
So they're only up the road then?
Basically, if you've got an SPT, get it renewed, get it recontracted now.
Again, what we're going to be doing within the management department, we are going to be running off a list of all of our contracts that are in rolling contracts, speaking to the landlords, speaking to the tenants and trying to tie them into another fixed term. Just to protect yourself, because this could become costly, especially if you've got more than one property. Okay, moving on, because I do talk too much and we'll be here till 10 o'clock otherwise. Banning orders. Have any of you heard of banning orders now? No? Nobody. Oh, wow. Okay, so banning orders. Really, really interesting. Every landlord in this room and us as agents could potentially now be banned from dealing with rented properties. You as landlords could be banned and made to, because then landlords are thinking, well, what do I do with my properties then? Give them away, give them up, don't rent them. You can actually be forced to use a managing agent if you are banned and put on the banned list. It's quite scary, actually. Banning orders, individuals, so you guys as landlords, also individuals that work within letting agencies, can be banned for housing offences. So, Sally talked earlier, Protection from Eviction Act. So if you went and did some unlawful eviction, if you didn't, maintain your repairing obligations, if you were prosecuted for any housing offences, you could be banned from being a landlord. We could also be banned too if we were found guilty of any of these. Immigration offences, that one's popped up again. If you're found guilty of immigration offences, you can be banned from being a landlord or a letting agency. Obviously, serious criminal offences. Anybody that's ever had to apply for a licence, if you've got HMOs or so forth, you have to do a fit and proper person test. And if you've ever been convicted of any serious criminal offences, you wouldn't be past the fit and proper person test. One of the staff that used to work for me, when I asked her what she thought one of those was, she thought it was somebody that went to the gym. Bless our little Ellie. And offences involving managed property. So that really relates to you as landlords and us as agents. If we're convicted of any offences that are involving managing properties, we could be banned as letting agents. Now, you'll be banned for at least 12 months. So if you're a portfolio landlord and you self-manage, you're then going to have to pass that all over to a managing agent to continue your business. Quite scary. I love this bit. There's actually a rogue agent stroke rogue landlord banned database, and it will contain all of the agents and all of the landlords that have been banned, which is a great thing. I think it's fantastic. If you have been banned and you're a rogue, don't you think we should know about that? We as agents should know about that, because if you bring up your property to me, I should know whether you're on the banned list or not. And if you bring your property to me, shouldn't you know whether I'm banned or not? Well, they have other ideas, because the only people that can access it are DCLG. We, as the public, can't see that banned list. We won't know who's on there, and you won't know if we're on there, but I can guarantee you that we're not. Okay, so this came into force in the 1st of October 2017, so quite scary stuff, really, that you guys here that have decided to make property your business, if you did something wrong, could be banned from continuing to do so. And alike for agents. Me personally, I hope it would get rid of the rogue agents and the rogue landlords, but who knows? So the Deregulation Act, I've covered this before and I've got literally 10 minutes left, so I'll go over it very, very briefly. Hopefully you all know now that at the start of every single new tenancy, you have to carry out, here's another list for you, just some more instructions. You have to make sure that the smoke alarm and any relevant carbon monoxide detectors in rooms that have solid fuel are installed and are tested on the first day of the tenancy. And you need to document that. Because remember, if you go to serve notice later down the line, you need to have your evidence. You also need to give them the how to rent guide, the gas cert, the licence, the EPC, and the whole list of long things that you have to give to a tenant now before they move in. That must be done in order for you to be able to serve notice on that tenant throughout that tenancy. We offer a rent guarantee service, and rent guarantee claims now, I may as well just start, jumping through hoops from the minute we submit a claim, because the amount of things that they want from you now and the amount of things that you've got to provide and prove evidence of is just humongous just to get the claim accepted. Because what's not listed on here, what you've got to remember is what Sally again mentioned earlier, retaliatory eviction. So landlords that don't want to do maintenance and just say, do you know what, just kick them out, give them notice, you can't do that anymore. Because if they've got an improvement notice put on that property, you can't serve Section 21 for 6 months. You have to keep that tenant and you'll have to do the work.
Even if they're not paying the rent?
Absolutely. And a lot of landlords say to me, I'm not doing that work, they're not paying the rent. It's actually the worst time not to do the work. It is absolutely, honestly, can't tell you enough, it's the worst time to not comply with your obligations, because if the tenant's not paying the rent, the likelihood is you're going to have to take them to court to get them out. If you turn up at court, Mr. Landlord, and you haven't done your maintenance, that Section 8 can be thrown out. It really can. And a lot of landlords, morally it feels wrong, why should you do repairs?
It's for them not to pay the rent.
One of the questions in the rent guarantee claim now when we're making it is, have there been any complaints about maintenance? And if there have, can you provide me with the complaint that's been given and your response so that they can see whether it's adequate?
But if they don't complain about any repairs,
Okay.
then there's no problem then, is there?
If you are not aware of any maintenance,
They haven't made any complaints to the estate agents.
yeah, if you're not aware, I'm going to be clear here, if you're not aware, if you are aware but they didn't complain but you know that there's a big hole in the roof, you've got a problem. But if you're not aware, you can't repair. So if you are aware though, you must. And you now have to respond to a tenant, I don't know who knows this neither, but you now have to respond to a tenant in writing within a reasonable timescale and keep that documented. It's a lot easier now because we've got email and text message and things like that, but you can't have a verbal conversation. It's got to be in writing within a reasonable timescale, any response to maintenance. I would say so, yeah, it's in writing, and if you just keep the trail, it should be. Section 21, major changes, this is what we're talking about now. You should all know that now the Section 21 is a Form 6A. It's a prescribed form. It's no longer just a written format. It has to be the prescribed form. And you have to make sure you've complied with all of these requirements before you can serve a notice. It has a 6-month expiry, whereas before, I think the longest successful Section 21 was 6 years after it was served. Now it only has a lifespan of 6 months. And the other key factor is to remember you cannot serve it any sooner than 4 months after the tenancy started. So in a 6-month tenancy, you have to allow 4 months to pass before you can serve it. Anybody that's got licence, because this is the one that gets missed off, because it doesn't apply to everyone. Most people know about GASA, how to rent and everything else, but if a property is licensable, you have to have given the tenant the licence prior to the start of tenancy, or you can't serve notice. And there's been a couple of things in Willenhall and Walsall, where they are looking to introduce selective licensing. Anybody you've got properties in those areas? Yep. So they are looking to bring it in those areas. There's please look into it, because there's actually a meeting to discuss with landlords and people within that area as to whether they think it would be worth it. No, it's going to be selective licence. If the council selectively licence an area, they will say this area, no matter what property is in there, a 1-bed flat, a 2-bed, will need a licence. And roughly at the moment, I think the licence cost is about £600. Yeah. They're running it for 5 years. Well, we had Liverpool, and they brought this out in 2015. We're now at the end of 2017, and we've only just got our first batch of licences through. The scheme ends in 2 years, and they're not going to renew it. But, you know, if you need a licence, you've got to comply. And again, when we served Section 21 on one of our tenants, the first thing the council said to us was, can I have evidence that you've given them a copy of the licence? And I said, yeah, if you give us one, we applied for it 2 years ago. Oh, okay then. Evidence of having the application submitted was enough, because we can't issue a licence that the council haven't given us. But bear that one in mind, because it's one that people forget. Article 4. Okay, this is in effect now in Wolverhampton. Any HMO landlords in here? You guys over there? Yep. Okay, so Article 4, what does it mean? as we know HMOs at the moment, HMOs, how many tenants do you think how many tenants does there need to be to create a HMO? What do we think? 3? Anything else? 3. Okay, absolutely correct. Any tenancy that has 3 non-related individuals sharing a property, it is a HMO. Now, where people get confused is if you have 5 or more tenants and it's over 3 floors, it's classed as a licensable HMO. But nevertheless, 3 non-related individuals, you are in effect creating a HMO. There's hundreds of properties where 3 people that are non-related live together in a house. And for years, we haven't had to class it as a HMO. But Article 4, what it means is that all properties from September the 14th, 2017, that the council deemed to be having a change of material use. So is it C4 to C3 or C3 to C4? So basically from residential to HMO, they must apply for planning before you do so. So I'll give you a scenario. We had 3 nurses. This is very common. Property down on Bentley Bridge, 3-storey property, 3 nurses. They all know each other, work together for years. They want to rent a property. The property that they want to rent has never been used as a HMO before. It's a single let dwelling. But we're now about to turn it into a HMO because these 3 people are not related. So this landlord now has to apply for planning because we're changing the use of the property. This doesn't apply to HMOs that are already in existence and you can prove that they have already been operating as a HMO. So Martin put his hand up earlier and said that he owns HMOs, which he does. 6 people live in Martin's HMOs, but he won't have to apply for planning because it's not retrospective and we have evidence that they've been operating in that manner for the last 6-7 years. But we have to be compliant. So what we said to our landlord in this case was, what we need to do is we need to treat this as a HMO for the compliance elements. So we will have to put in a fire door on the kitchen. It will have to have mains operated smoke alarms throughout on each floor interlinked, not just battery. It will have to have a mains operated smoke alarm in the lounge, so an additional one. A fire blanket and a fire door on the kitchen. And basically, on the bedroom, we didn't need it. On the bedroom, we didn't need it because it was a 3 people. What we needed was fitted doors that closed well, but with self-closers on. So basically, all we've got to do is comply with HMO regulations, but we don't have to apply for planning, even though the rules tell us that we do. So I said to her, okay then, so what if we fall foul of this? What are the penalties? She said, we'll write to you. I said, oh, okay. I said, and then what? She says, well, after we've written to you and we've told you to fix the problem, what we'll do is, the next step is we'll put a charge on your property. I says, oh, okay. And she says, and then you can appeal it if you want to, and that'll take about 9 months. She said, so basically, in about 2 years, what will happen is we'll prosecute you if you're still operating it illegally. So basically, they've not got anything panned out to deal with this properly. We as landlords, we as agents, don't really know what to tell you because, for me, the rule book says 3 to 6. This needs planning. They also told me that if it's a house that they would have granted planning on, even though you haven't got it, they wouldn't pursue you anyway. So, what we've said is, if you do get any tenancies where there are 3 sharers that are non-related, please call the council and speak to the lovely, intelligent, informative lady who will probably tell you you're not changing the use of your property and you don't need planning. And where possible, get that in writing. To make sure that you don't fall foul of this, new regulation. But what I will say is, if you are going to be renting room by room, and that's on individual tenancies, not because this scenario, remember, we are talking about 3 friends, we are talking about 1 tenancy. If you're doing it individually, if you're putting locks on the doors, the whole situation changes. You are now entering HMO change of use territory. and you therefore will most likely need to get planning. And that's from anything between 3 to 6 tenants. Okay, so energy efficiency, as you already know, as of April 2018 next year, every single property that we enter a new tenancy into has to be a minimum standard E on the EPC rating. Quite straightforward. It's not retrospective, but bear in mind what we've talked about today by way of going into a rolling contract, by a renewal of tenancy, that will be deemed a new agreement. EPC standards, since they started 10 years ago, and EPC assessments have apparently changed substantially since then. And what they check for and what they take into consideration when doing an EPC also have improved. So what might not have been an E rating in 2007 may well be an E rating now, because they consider a lot more things. What was it that you said, Sally, that they...
Floor insulation they didn't account for 10 years ago, but now they do.
Yeah, so there's certain things that do. But the main contributor to an energy efficiency rating is the boiler. So if you have got properties where there's an old boiler, just merely by changing that really could raise the energy efficiency of the property. But again, this, and then in April 2020, this is going to be retrospective, so it will be on all homes whenever they were rented. So in theory, what they want is energy efficiency across the board on every single tenancy in 2020, E or above. However, listed buildings don't need EPCs, so therefore you don't have to get an EPC. However, if you've got an EPC on a listed building and it doesn't comply, you've got a problem. By having an EPC, when you don't need one, means you have to comply. But then there's certain restrictions, and this is where it goes on for. There are restrictions, because the rule to this is every landlord's property must be EPC E rating or above. However, it must cost the landlord no money to get it there. So you're not expected to spend money. It's the only good thing we've heard tonight, yeah? We've got to get to the rating, but it's not going to cost you nothing. So basically, you as a landlord have got to be able to have access to a Green Deal deal. And whereby the improvements to the property don't cost you as the landlord any money. And as Sally said earlier, if that is the case and you don't have the access to the Green Deal and you can't, you have to get a certificate of exemption to say that we're exempt from these EPC regulations. But be prepared to act, because I know one particular landlord that has been with us for a long time, and he's got about 10 properties, and every one of his properties falls below that rating. So we've been talking about this now for about 2 years, but many landlords probably haven't done anything in that time scale. Now imagine he has to do all 10 at once. It's better to just do bits and bobs and improve. And as the EPCs are now running out, getting new ones just to see has the efficiency changed. Because EPCs are not expensive. Okay, Housing and Planning Act. We're nearly finished, just 2 more slides. I'll just keep you for 5 more minutes, because Sally keeps looking at me evilly. Okay, so the Housing and Planning Act 2016. Everybody in here heard of the Housing and Planning Act? That's another piece of legislation coming your way that will tell you that you have to now do electric testing. Okay, so again, anybody that's let properties through us know that we already insist on having electric checks on our properties that we rent out for you, because we do believe that we should be offering safe and you know, comfortable environments. And how can you tell if the electrics are safe if you've not had them tested? So whilst we don't disagree with what they're doing, it is another piece of legislation that you guys are going to have to comply with. But we don't know what yet. We don't know, is it going to be fixed periodic every 5 years? Is it going to be every 3 years? Is it going to be yearly? Is it going to be visual inspections, which is what we accept? We don't know what, but we know this is coming. It's coming very, very soon. Mandatory CMP. Do you all know what CMP is? Interesting. Okay, so you're all landlords, and does anybody have their properties managed in here, or have we got just let-only landlords? Don't they? Diane and Kevin, do you know what CMP means? It's really interesting, and Dave over there, you do. CMP is called Client Money Protection. You lovely people here entrust us to take your rent every month and hold all of your tenants' deposits in our bank account just because you must like me. But one day I might have had enough of this life and this cold weather out there and the snow that's coming, and I might decide to take all of that and go and live the high life in Marbella, like, or buy a new car like I've done today. I promise I didn't touch the deposits. But seriously, agents, you trust them with your money, your deposits, your rent every month. We have hundreds of thousands of pounds in the bank that one of the agents about 4 years ago did actually do and just disappeared to Marbella. And you don't know what client money protection is. So therefore it just tells me that landlords don't know when they're choosing an agent to ask the question, do you have this? Because it's not mandatory for agents to have it. To put all of your minds at rest, we do. And if I decided to take the money and buy a new car and run off to Marbella, you would be guaranteed to get your money back under the insurance that we have under the client money protection. But Arla in particular have fought and fought and fought to make this mandatory for every letting agent, because you as landlords shouldn't have to check that. You should deem that if you're choosing to use an agent, they are professionals and, you know, that your money is safe. You should have that peace of mind. So that for us is a massive thing that we're pleased about, will be coming into force very, very soon. But just, these are things that we've talked about earlier. So fines now, do you all know now that, you know, you get a penalty charge notice on your car if you park there illegally, and it's like pay within 14 days and so forth. These are the type of things now that councils are now issuing. They're called penalty charge notices, fixed penalty notices that they issue on landlords when they've done something wrong. But the good thing for them is the council get to keep the money. When things go through court, did you say, Sally, the money goes to the government as it stands? So councils are not really bothered because it doesn't benefit them. But now, if they give you a 30 grand fine, that's going in their back pocket, and that council worker that's managed to get 60 grand in fixed penalty notices this year is going to be getting a pay rise and going up the ladder in the council. So for them now, and I sit on a meeting through Arla called Home Stamp, and I basically sit in a room with a representative of every council in the borough, so Solihull, Birmingham, Warwick and so forth, and they're all really excited about this because this is income. This is income for them, because every notice that they serve and every payment that they receive will go to them and not the government. So they're incentivised to be charging you landlords now if you break the rules. The fines now are so much higher, £30,000. That's a huge amount of money for a housing offence. You can commit murder and you probably wouldn't be fined at all. You might have a few years in jail. But don't forget, you can have that with the Immigration Act now as well. Banning orders, which we've talked about, the fixed penalties, and the fact that all of this information now is held with the TDP, which is the deposit people. Because who knows most about landlords' names, tenants' names and property addresses? The deposit schemes, because we all have to use them. So,
No, we don't.
we don't all use them.
Some people don't.
Lots of people don't.
Yes. A lot of people don't.
They're going to fall very foul to any...
What if you don't have to take a deposit then?
Well, if you haven't got a deposit, there's nothing to protect.
Well, that's what I'm saying. I think is that the point? You know,
There's a lot of...
I know a few landlords who haven't been taking deposits for years
because of this. And a lot of landlords tried to cheat it as well. They'd say, right, I'll take 3 months 3 months in rent in advance and you start paying me on month 2. Well, you can't do that no more. It will be deemed as a deposit. Honestly, now, I have to say, deposit registration for me has never been more important if you do have a deposit, because it is going to wipe out your opportunity of serving Section 21. And Sally mentioned earlier that, you know, the long list of stuff that we've just gone through, you can still actually serve Section 21 if you failed to comply with that, but you would have to serve all of those documents prior to serving the Section 21, and you'd have to hope that you could get it through. Yeah, it's going to be a bit of a grey area because you didn't do it at the start, but you've rectified the problem before you've served the notice, so in theory you should get possession. If you've registered the deposit late and you've not complied with those, so let's say you think, oh, I need to serve Section 21. Oh, I forgot to register that deposit. You can't just register it and serve notice. It won't work. The only option really that you've got is to give it back to the tenant, and then you don't hold a deposit, and then you're free then to serve the notice. But they could still come after you for the 3 times the amount plus the deposit.